Hey YouTube family and GN subs, how are you? What's going on? We're hearing a lot about, this new 212A9 3 and 10 year bar rule. There's some new law. People are confused. I'm going to break it down for you. I'm going to make it very simple to understand because I'm looking out there, folks, and it's crazy the way that people are trying to make this way too complicated, all right? So I'm going to break it down. Those of you who are new to the channel, my name is Humberto, Gray Attorney at Law, and one thing that I do is I give you good news, and today we have tons of good news. Like and subscribe, go to my playlist, check it out. Actually, let's have a little bet. You go to my playlist, I guarantee you will subscribe to my channel. All right, so a lot to unpack today. Let's get at it. All right, I've had tons of calls in the last 2 weeks from my clients. Humberto, what is this new rule on the 3 and 10 year bar? What's going on? I don't understand. I've tried to understand it. I've tried to listen to, Spanish news. No one's telling me what's going on. So let me break it down for you, okay? So there's a recent case, Velasco de Gomez, came down May of 2022 versus USCIS. And this case is a great case, okay? It's a really good case for what we call the 3 and 10 year bar. Let's break this down for you, make it very simple. 212A9 has two sections, okay? You have 212A9B and 212A9C. Don't confuse the two, all right? So let's talk about the first one, and that's what this case refers to. So 212A9B says that if you have been in the U.S. illegally for less than a year, there's a 3-year bar. If you've been in the U.S. illegally for more than a year, there's a 10-year bar, okay? That's pretty simple stuff. Let's talk about the 212A9C, all right? That is a permanent bar. If you've been unlawful in the United States for more than a year, you depart the U.S. and you re-enter the U.S. illegally, that is the 212A9C bar, which is a permanent bar. That's not what this case is talking about. That's not what it refers to, all right? So let's go back to 212A9B. So 212A9B, there was an interpretation that basically you need to wait out of the United States for 10 years before you can apply to come back in the United States. That wasn't what the statute said. The immigration lawyers sued USCIS, and so just last week, USCIS announced, yes, you're correct, you can wait the 10 years in the United States, which is great news, folks. So how does this work? All right, let me give you an example. So let's say you're in the United States unlawfully, you go out of the United States, you wait out, let's say you wait outside 8 years, right? Or 5 years, it doesn't really matter. You go to the US consulate, somehow you get a visa, you come back legally, you're inspected, you're admitted. You come in with a visa, so you file your adjustment of status. USCIS was interpreting, no, you have to stay out of the US for 10 years before you can come back and adjust your status. So that's not going to be the case. You can wait the 10 years in the US. That is great news, folks. That's a huge case. All right, some more good news. Visa Bulletin, July 2022, family sponsor cases. Heads up, guys, file your case. You're going to be able to use the dates for filing as opposed to the final action dates to get your family petitions in. You know the Visa Bulletin's been stuck, right? It's been stuck, it's been stagnant. You're probably waiting to file that adjustment of status. You can't. Well, July is going to be huge movement. Look at this. In the F1 family category, it's a 1.5 year difference, right? F2B, F3, look at that, 1 year difference. So, you can use that, your priority date, look at the Visa Bulletin, file your adjustment right away. Because if you file your adjustment, right, in July, if you can, right, if your priority date are those dates, if you can file your adjustment, you're going to remain legal in the U.S. You can get work authorization. You don't have to, stay on your F1 student visa. You can move around. You can travel on advanced parole. So it's fine, and you could just wait at that point until the final action date comes and your case is current. Your adjustment will stay pending, and you have a lot of ability to do a lot of different things in the U.S. So look out for July 1st. If you can file your adjustment, file it, folks. All right, another bit of good news. Our Supreme Court said the public charge rule under the Trump administration, which made it impossible to qualify and get, a green card because, Immigration, State Department, they could, in their discretion, say that they believe you are going to be on public charge if you come to the U.S. That I-864, that affidavit of support. It became 50 pages. It was impossible to complete. You have to show assets. You have to show a lot of money to be able to qualify. The average immigrant couldn't do that. So the Supreme Court said, no, the Biden administration was correct in saying that they would not enforce this new public charge rule, and it went away, and it's still away thanks to the Supreme Court. That's good news, folks. All right, another bit of good news. You might not know this. CDC recently said that you don't have to get a COVID test to come back to the U.S. So those of you abroad, you want to come back, you don't need to take the COVID test, get on the plane, get back in the U.S. That's good news. Finally, really good news for Cubans and Haitians, okay? There is a program, the Cuban Family Reunification Program and the Haitian Family Reunification Program, where they are allowing Cubans and Haitians to be paroled into the U.S. while the family cases are pending. So if you have an approved petition, let's say family-based petition, it's approved, you're just waiting for the priority date, you can be paroled into the U.S. from Haiti or Cuba. Come here, wait, get work authorization, etc. That's great news for some Cubans and some Haitians. That's really, really good news. By the way, the U.S. consulate has opened back up there. Great stuff, folks. All right, let's talk about some real cases, all right? Let's talk about real cases. I just experienced continued waiver of final interview for a family case base. It was actually a marriage petition, a second preference petition. Interview was waived. The wife, as well as the following to join daughter, got green cards through adjustment of status here in the United States. Final interview waived. That's huge. I mean, usually they want to see that the marriage is valid. Basically, in this case, the piece of evidence that I put in was that the petitioner, permanent resident status petitioner, adopted the daughter, right? And we put that in. I guess that solidified the case, made them approve it without an interview. That's great news. Finally, look at this, okay? We talked about H's, L's, E, spouses who have work authorization. I got my first I-94. You see the S designation on this? This means that without filing for a separate I-765 work authorization, you are able to work. So on your H's, L's, E's, note on your I-94 if it has an S. That means that you have authorization to work in the U.S. Hey, YouTube family and GN subs, thanks so much for watching GrayLaw TV. I really appreciate you. Channel's growing. It's a lot of fun to give you, up-to-date information on what's going on. And, you newbies, BGN subs, that's good news subscribers, baby. Join, and we look forward to having you. I do answer questions in the comments. If you leave a comment, I try to answer every question, especially for those GN subs. All right, we'll see you next week.